I'm going to talk about Commanding Officer's summary hearing. I've previously provided videos about JSP 830 and the Manual of Service Law. The Manual of Service Law JSP 830 Volume 1 provides details about the procedure that must be followed at Commanding Officer's summary hearing. And in particular, I want to talk about the information that must be provided to an individual at least 24 hours before the Commanding Officer's summary hearing. So this is not court-martial, this is at the CO's hearing. At that hearing, the individual has the automatic right, should they so wish, to decline the CO's jurisdiction and to elect court-martial. But assuming that they do not do that and go on and have a hearing before the Commanding Officer, or even if they decide to elect court-martial, they must be provided with a series of documents that must be given to them at least 24 hours before that hearing. So included amongst the list of items that must be provided to an individual at least 24 hours before the Commanding Officer's summary hearing are the charge sheet. They must be provided with a copy of the charge sheet setting out the charges that they face. They must also be provided with a copy of the case summary. At least 24 hours prior to the summary hearing, the individual must be provided with a copy of the written evidence relevant to the charge against them. And the written evidence will normally be in the form of a Section 9 witness statement, and I have previously provided video relating to Section 9 witness statements. The individual must be provided with details of any exhibits and where they can be inspected. The exhibits may, for example, include military police interview discs. Prior to the Commanding Officer's summary hearing and at least 24 hours beforehand, they must be provided with a copy of the disciplinary record. They must be provided with a copy of any material collected during the investigation that is not intended to be used. This is known as unused material. In some instances, a Commanding Officer will be given higher authority permission to extend their powers. If that applies, then at least 24 hours before the hearing, a copy of any permission of higher authority for extended powers must be provided. These can include prior authority to extend detention from 29 to 90 days, prior authority to impose a reduction in rank or disrating, prior authority for removal of seniority in the case of officers, prior authority for a Commanding Officer to impose a fine of between 15 and 28 days pay, prior authority for detention, but this only applies to leading hands and below in the Royal Navy, Lance Corporal and below in the Royal Marines and the British Army, and Corporal and below in the Royal Air Force. And 24 hours beforehand, an individual must also be provided with a copy of any permission to allow the Commanding Officer to hear more serious charges, and crucially, at least 24 hours beforehand must be provided with the time of the hearing. So that is a list of the documents and evidence that must be provided at least 24 hours prior to any summary hearing. So they include the charge sheet, and that will actually set down what it is that the individual is alleged to have done, the actual offence that they are alleged to have committed. The case summary is exactly as it sounds. It's normally no more than one side of A4. It is a summary of the allegation against the individual. So what the prosecution or what the unit wish to try to prove against the individual. The written evidence will normally be in Section 9 witness statements, and I previously provided a video about Section 9 witness statements. This is important because it may be that an individual, having read the Section 9 witness statements, may wish to have the individuals who made the statements cross-examined, and that may mean that they have to insist to their commanding officer that those individuals be present in order for them to be cross-examined. So the written evidence, the Section 9 statements, are particularly important because it may be, depending upon the circumstances, that the individual may be able to cross-examine the individuals who have made those statements. And it may be that in cross-examination of the individuals who made the witness statements, it may be that the defendant may be able to put across their defence. Other material that should be provided is, for example, the military police interview discs. So if the individual was interviewed under caution, a record of what was said. May also be, if they were kept in custody, their custody record, or any notes that were taken by anybody investigating the matter. All those matters need to be provided at least 24 hours beforehand. And likewise, the unused material. Unused material is exactly as it sounds. It is material that has been gathered during the course of the investigation that is then not used by the prosecution when presenting the case. And it may be that there is material within the unused that can be helpful to a defendant in defending their case, in presenting their defence at summary hearing. They must also be provided, for example, with their record of any previous convictions that they have, any antecedent history, anything of that nature. And then crucially, if the commanding officer has been given extended powers, higher powers, then that authority must be provided at least 24 hours beforehand. So for example, as I previously provided in other videos, commanding officer's powers are normally limited to no more than 28 days detention. In some circumstances, higher authority may be given to a commanding officer to impose a detention period of up to 90 days, so between 29 and 90 days. But if that power is available, then a copy of that authority must be provided at least 24 hours beforehand. So that's a brief overview of the material that must be provided to an individual at least 24 hours before any summary hearing.